had taken you through the language of the Dutch agreement and dealt with the point about success. I think I'd also said something about commercial common sense. The learned judge, at paragraphs 88 to 89 of the judgment, made the point that there was nothing about our interpretation, the interpretation that he found to be correct, which was lacking in common sense. The idea that someone should get paid a success fee on the happening of contingency, and not if the contingency didn't happen, as the learned judge found, and we submit correctly, makes perfect commercial sense. Contrary in our submission, the other side's position, as I say, their position is that the 30 million was payable from the outset, and that the only point about the later event was a timing point. In our respect for submission, given the background to this contract, where Richard says that he really should have had another 1.9 million, the idea that he entered into a contract which gave him an immediate entitlement or immediate right to 30 million, albeit that 27.4 million was deferred, in our respect for submission, makes no commercial sense at all. It's completely contrary to what he says he wanted to achieve.
This is 82 to 84. Does he deal with the timing points there?
No, he doesn't.
He doesn't deal with it.
I'm not sure that was run in this way.
Right.
Below.
Right.
The learned friends have developed their case. I think is it paragraph 51(2). Now make the time point explicitly. That was an immediate obligation, which arose because there was success in the settlement, that you had an entitlement to 30 million, and the only point was to defer 27.4 to a
Of course, it's the deferred payment point.
Exactly.
Yes, sorry. Did Mr. McGrath this morning take issue with the suggestion recorded by the judge at 82 that the calculation of the 2% is based on the sale price?
Yes.
He did?
He did.
So is the judge slightly wrong? He may say it doesn't matter, but is he slightly inaccurate in what he says then in paragraph 82?
Well, that's certainly what Mr. McGrath said. His argument turns on paragraph 6.
Yes.
As I understand, and the language which says...
Well, it's 2% of the value attributed to the 50% whole.
In my respect for submission, read sensibly, if I can put it that way, that is plainly attributed to the 50% on a sale.
Yep.
It's not outside of the context of the sale. So in my respect for submission, the learned judge was right about that.
Just need to speak up a bit.
I'm so sorry.
Mr. Rabinovitz, I am having difficulty. You drop your voice at the end of a sentence.
I will ensure that I don't do it anymore. I will shout at you. That is the subject to any points that the court has that it wants to raise with me. We have language which indicates that this was only payable in the event of a sale, and that is, in our respectful submission, entirely in accordance with the commercial common sense of the position. Standing back then, the learned friend's case has to be that in the ordinary process of analysis, where you look at the language, you look at commercial common sense, and you also have a look at factual matrix. Learned friend's case has to be that there is something in the factual matrix which should lead this court to disregard the language in the contract. And it is, of course, the case, as the learned judge said in his analysis, factual matrix is always relevant. You should always look at factual matrix. But factual matrix, save where it enables you to identify that a mistake has been used with the language, does not entitle a court to disregard the language. It is intended to ensure that the court is better able to understand the meaning of the language. There are limits to the use that you can make of factual matrix. In our skeleton argument, we, at paragraph 31, page 46, I've got the reference wrong. It's at paragraph 44, at page 47, we identified certain authorities which make this point. Can I just summarize?
And so this is ground 2.
I'm now on to ground 2, because that's all there is to say about interpretation. So ground 2, factual matrix. And just by way of an introduction to the the issue of factual matrix, there are 2 points to make about factual matrix in terms of the parameters of the use that can be made of factual matrix. The first is a legal point, and the second is a procedural point. And the learned judge referred to both of them. So far as the legal point is concerned, your lordships and your ladyship will have seen that the learned judge refers to the passage in Lewison where he makes the point, Lord Justice Lewison makes the point, that factual matrix should not be used in a way which involves a complete disregard of the language. We set that out in paragraph 44(1), and we also cite Jones and Commerce Bank, which was an authority cited in Lewison as well. And if I can invite your lordships and your ladyship just to look at that. Your lordships, and the court also sees Benjamin developments, where Justice Hardy Boys put the point in a way which, again, we respectfully submit is helpful. One can't go to the factual matrix as a way of undermining and enabling the court, absent some claim for rectification or mistake, to disregard the languages. With respect, that is exactly what my learned friend is saying here. My Lord the Master of the Rolls looks a bit quizzical about
Well, it's just a lovely quote, isn't it? Hardy Boys.
I would respectfully agree, my lord. So that's the law. Factual matrix is there. It is useful as a way of interpreting the language. It is not. It doesn't give you the pretext to disregard the language. But that's what the learned friends seek to persuade this court to do. That's the legal point. The practical point is this. As the learned judge noted, the commercial court guide makes clear that if you have some factual matrix you want to, and I'm sure it's in the Chancery Guide as well, if there is some factual matrix on which you want to rely, you have to plead it precisely. And there's a good reason for that. People need to be able to understand from the outset what are the points of factual matrix that you say can make a difference to the interpretation of the contract. And the point about factual matrix, which is important to note, is it will always be something which is known to both sides, necessarily, because if it's going to be a factual matrix, it's something that will have to cross the line and be within the common knowledge of both parties. So it's not the sort of thing where one can say, we need to get to trial to see what comes out. We need to get to disclosure to see what comes out. You must know when you plead a claim what the factual matrix points are that you want to rely on. The approach taken by the learned judge, in our respectful submission entirely correctly, was to recognize factual matrix as important, to refer to the Lewison authority as a way of limiting how factual matrix can be used, and to make the point about the commercial court guide, and to say he was therefore entitled to look at the pleadings to see what were the matters of factual matrix which were said to be relevant. I just want to make one other general point about factual matrix, and it's this. The learned friends criticized the judge for, in a sense, not waiting to trial to see the light which is put on these matters, to see how things develop. As the court noted to my learned friends, the basis upon which this application was made involved our acceptance that the court should regard anything said by my learned friends as properly admissible factual matrix to be true, that you don't have to wait. Just take their case at the highest. Assume all of this will be established. Is that sufficient to move the dial one jot? And the learned judge concluded not. He also concluded that actually most of the factual matrix points that were being made by my learned friends below actually assisted the interpretation of the language to which he thought was the right interpretation. And you recall his reference to the Anzer Agreement, and indeed paragraph 22, which I'm going to take you back to.
Just to take your pleading point, however, the facts and matters that Mr. McGrath referred to this morning were pleaded.
I'm not.
So we get. I mean, we get 15th of June notice pleaded. I'm just looking.
I'm not excluding any of that.
No.
At all.
No.
I'm just saying that was his approach, and in our respectful submission, it was a perfectly appropriate approach. But you can look to the pleadings to see what is conceivably relevant factual matrix. And the reason I say conceivably relevant factual matrix is because if it is inadmissible, because it relates to pre-contractual negotiations, then it isn't factual matrix at all. Now, when my learned friend was making his submissions, and I think he must have been on ground 2, he took you to paragraph 22 of his pleading. And if I can, that is the paragraph to which I would take you to as well, because I would accept that this is perhaps the most important factual matrix provision allegation that there is. The learned friend read it to you. I'm going to just, your Lordship and the Ladyship have seen it. In light of the above, the claim, RB negotiated and agreed 2 things, 1 and 2. And then we have the bit below, which is the important bit, I think, as my learned friend recognised. And there are 3 points that arise here. While a sale of the entire group was understood at the time to be the intended divestment of the MB Trust assets, just pausing there, that's the first thing that was said.
Sorry, I must be in the wrong place.
Paragraph 22?
Oh, yes.
Below the 2
as noted at paragraph 26.
As noted.
Yes, sorry, yes.
As noted above, while a sale of the entire JCB group was understood at the time to be the intended divestment of the MB Trust assets. And again, that is common ground. It was understood to be the intended divestment of the MB Trust assets. And indeed, that's obvious from the touch agreement itself. Then you have this. Since other forms of divestment restructuring had been the subject of prior consideration and remained possibilities. Now, 2 points arising out of that. The first thing is there were other forms of divestment and restructuring which had been considered in the past. And again, for the purposes of this application, we accept that that is true. My learned friend regards this as a helpful point for him. In our respectful submission, as the learned judge concluded, it goes exactly the other way. Because you have a situation which, as a matter of factual matrix, the parties were aware that a number of other forms of divestment and restructuring had been considered, but they chose one specifically and expressly. And that is the one that was going to be the trigger for the payment of the 2%. They could have chosen these other ones. They could have said any form of divestment, etc. But they didn't. They chose one of these divestments. Perhaps because, obviously because it was the front runner. But that is the contract that they were happy to make.
Did you stop deliberately after consideration?
I did there.
Yeah.
Because the next point also matters. They remained possibilities. Now, that matters because there is a great deal of suggestions made in the learned friend skeleton that a sale was certain. And indeed, that is what, and indeed he runs a case, which he didn't develop orally, but since you have his skeleton, I ought just to deal with it, that this is a case like Nagel and Plusnik, and indeed Munich, where the circumstances outrun the contract. There has been some unforeseen circumstance which arises, and that you have to interpret the contract to take into account the unforeseen circumstance. Just to remind you of the Plusnik case, the Nagel case. I'm not going to do the Munich case because it gets complicated and my lady will know all about it. But the Plusnik case is an easier example to develop what this is about. In Plusnik, this is all about the De Beers sightings and sight holders, where the system was, if you wanted to buy diamonds, you had to buy them through De Beers. You had an opportunity to buy a box. That opportunity was only made available to sight holders. There was a point in time in which a sight holder was required to appoint a broker. And it was in that context that the contract between broker and sight holder was made. Beers then changed their rules, and it wasn't any longer required to make a sight appoint a broker. It was recommended, you could or not. And the argument, and what happened was that the sight holder terminated the contract with the broker and said, well, we're no longer required to appoint you, we don't need you. Mr. Justice Leggett, as he was, identified the doctrine that where you have unforeseen circumstances which arise, the court has to deal with it and to try and understand, by reference to the language used in the contract, what the parties intended to happen in those unforeseen circumstances. Plainly, if the unforeseen circumstance was a frustration, that's easy. You don't have to do anything else. But if it's short of a frustration, you have to interpret the contract to try and understand what the parties intended to be the position in terms of rights and obligations in the happening of that unforeseen circumstance. Now, with respect to my learned friends, although they identify this as one of their ground one points, this has got, obviously we do not take any issue with that being a doctrine of law. It's a well-established doctrine of law, if that's the right way to call it. It may be an approach to interpretation rather than doctrine of law. The problem about that point for this case is, A, we're not dealing with an unforeseen circumstance, and that is apparent from my learned friend's own pleading, because in his own pleading he says it was the other approaches remained possibilities. In a sense, it's obvious that a sale is not certain in any event. It was just a plan. But B, his own pleading says the other approaches remained possibilities. So we're not dealing with an unforeseen circumstance at all. And B, it's impossible to see how this helps him. Because even if one is in this, I'm going to call it a doctrine, of unforeseen circumstances, what Mr. Justice Leggett says, and what my Lady Justice Carr said in Munich as well, is that you have to interpret the language of the contract in order to understand what the parties intended. In other words, where you have the situation, interpret the contract. That doesn't seem particularly profound, but one is thrown back onto the analysis which the judge did. That is precisely what he did. He interpreted the contract. So that does, with respect, bit of factual matrix doesn't help my learned friends. The third bit that comes out of this, which in my respect for submission doesn't help him, is that it was understood, albeit not expressly discussed, that the 2% fee applied to any other arrangement upon completion. Now, the court and my learned friend had a fairly lengthy discussion as to what was meant by it was understood that the 2% fee applied to any other arrangement. And in the end, I'm not sure that my learned friend pushed this very far. But the important point for our purposes is that it wasn't expressly discussed. Now, given it wasn't expressly discussed, it's not at all clear where this goes. There's not a rectification claim, nor could there be. It's not an estoppel case, nor could there be, because it wasn't expressly discussed. The most that I think might be said is that it was the unarticulated understanding of both sides that other approaches remained possibilities which may be used.
Obviously, there isn't a rectification claim, but are there aspects of the appellant's case which are more consistent with the rectification claim than anything else?
There may be.
Yeah.
One's not being brought.
Yeah.
I can only, in a sense, strike out the claim that is.
No, I understand. I understand.
And that's why
you can't strike it out at all, actually.
I beg your pardon, my lord? No, of course. Of course. I apologise, your lordship.
But if there was a genuine common shared understanding
we might
of the type alleged here that had been advanced, but it hasn't been.
We might be in a different world, and that is why we made it very clear in our skeleton below and throughout that we understood there wasn't being there was no rectification claim, there was nothing else. They were simply relying on the terms of the contract, interpreted against the factual matrix background. There was nothing else. Plus, obviously, the implied terms, but that's the terms of the contract. Now, those, as I respectfully submit, and indeed I think my learned friend agreed, or at least seems to have agreed, given that he took you to it, are the main points of factual matrix that arise. Other possibilities existed, but they weren't the ones that were chosen. They remain possibilities, and that there was nothing expressly discussed about whether whatever my learned friend said, there was no discussion. I'm not sure what his point was in the end. Now, I don't understand that there was anything else. I can take you through the pleadings. There are matters here which appear in the nature of pre-contractual discussion, negotiations. And the learned judge took the view that that was not admissible. There was no dispute about that below. And I'm not sure that there's a dispute about it here either.
But the 2 points that Mr. McGrath has emphasised this morning are firstly the memo of the 15th of June, which was referred to in the pleadings, and the down payment on the reference to down payment. Those are the only 2 factual matrix points that didn't leap out at the judge.
I'm just trying to find the 15th of June memo.
It's in the supplementary bundle at tab 10. But it was really the point. If I speak over you while you get it up, it's that it was complex, and that there needs to be flexibility for a plan B should project. And you say that's
Fine.
more the same.
Let's assume there needed to be flexibility for a plan B.
And then
How does that help in terms of the language of this contract?
and then he went to tab 12 and referred to what may very well be, in more traditional senses, an inadmissible reference, but assume against yourself it's admissible. What do you say about the down payment? Page 71.
Well, I do say it is inadmissible.
Yes.
I don't think that is pleaded, but something similar is pleaded in the sense that his case is he was always entitled to the 30 million. And that is the case for reasons I've already made some points about it, but it really just doesn't work. The contract is very clear that you get the 2.6, and then if there's a sale, you get another 27.4. So, the down payment, first it's not clear what this is. This is Richard's own notes. It doesn't say, it's not an agreement between them as to what was said. Richard has come back and says, and for these purposes we have to accept that this is right. This is some contemporaneous note. Obviously, if this ever had to go to trial, that would be contested. But this is certainly something which comes out of negotiations and discussions, and is for that reason, in our respectful submission, inadmissible. And I'm not sure what language is supposed to give you a different meaning for. I'll put it that way. Lady, I'm happy to deal with any other point of factual matrix that comes out of it. Below, there was a lot of discussion about the ANZER agreement and the fact that that contemplated other means of achieving the separation.
Null and void he relied on.
Null and void.
19th of June, page 70.
Page 70.
Yes. But I think the point was simply to emphasise again the importance of separation of trusts. Sorry, second paragraph.
That's about the settlement. Yeah. If nothing happened, things would become null and void. But again, we don't dispute that the settlement was important.
No.
Thank you. It's difficult to see how that gets you anywhere. If you look at the touch agreement as involving two stages, one was the settlement, which is undoubtedly important, and two is Project Crepe Marsh. So below, I'm not even sure there was, but paragraph 13.6 of the pleadings was the comment about Mark used to walk around referring to Project Crepe Marsh more generally than the sale. When I intervened, I think I made some points about that. The learned judge deals with that at paragraph 66 to paragraph 68. He says, first, it's inadmissible, but second, even if it was, it lacks any conviction at all. It is inconsistent with what Richard expressly defined in the contract. It is inconsistent with the pleader of this document expressly regarded as Project Crepe Marsh on at least two occasions. It is inconsistent with what pleaders of the three previous draft particulars of claim which were threatened but never served, said about Project Crepe Marsh. There is no claim for rectification, there is no estoppel case, it really goes nowhere. So in terms of factual matrix, in our respectful submission, there is nothing there. Now, I'm conscious that I said I'd be finished in an hour, and I'm going to, I think I'm
not obliged to be finished in an hour.
No, I appreciate that, my lord. I'm still going to do my best. In the skeleton argument, there is a reference made to Professor O'Sullivan's article in, I think it was the LQR, which talks about the possibility of the courts, or English law, where it is dealing with an oral contract and an implied term, admitting evidence of pre-contractual negotiations. I just want to say three things very shortly about that. Number one, we're not in an oral contract, we're in a written contract. Number two, Professor O'Sullivan rightly notes that in the existing state of English law, pre-contractual negotiation material is excluded where you are construing express terms of the contract. And indeed, there are comments, both in Marks and Spencer's by Lord Newberger, and in the Phillips case by Lord Bingham, which suggest very clearly that the same rule applies to implied terms as well. And that, in our respectful submission, makes perfect sense. So it's an interesting idea. It's not consistent with existing authority. It wouldn't apply to this case. But even if it did apply to this case, with respect, it gets my learned friends nowhere. What Professor O'Sullivan suggests is that where you're dealing with an oral contract and an implied term, it may be useful, because you're having to hear evidence about what the contract was, to see whether parties did or didn't raise a possibility and whether that possibility was discussed and what was agreed or not agreed. Because it would help one where you're trying to decide whether something would go without saying, that is to say, where the officious bystander said, is this agreed? And one party says, you definitely have agreed that, because it's obvious. You could see what the answer to that was. But here we're told expressly, paragraph 22, that the matter wasn't discussed. So it's really not going to help with that sort of situation. So in our respectful submission, the article is an interesting one, but it really has nothing to do with this particular case. Where the contract has been reduced to writing, and paragraph 28 tells us that these are the terms of the contract. My learned friend in his skeleton argument also makes the point, and I think this is in the context of factual matrix, that where you're dealing with implied terms, they can be particularly fact sensitive, and there may be a particular need to see how things work out at trial, just to see which of two contested versions of the factual matrix turns out to be right. He cites the Irish bank case in this court, Lord Justice Beatson. What he doesn't say, and this isn't criticism, is that in the Irish bank case itself, the court was able to find that the particular contract pleaded was hopeless, even though it involved an implied term, and even though there was some factual matrix material, because of the express terms of the contract. There was no need to wait to go to trial. And again, this is an obvious point. There will be some cases where, by virtue of what he said about factual matrix and the implied term, it is necessary to wait. In this case, with respect, we're not in that position. We've accepted all implied, all factual matrix you should accept as true. For that reason, you don't need to wait. The problem about that is that anything said in the context of factual matrix just cannot really move the dial when you look at the language of the contract. So again, Irish Bank, again, a point made which, in my respectful submission, is obviously right, but it doesn't make any difference in all the facts of this case. Now, subject to the court, that is all I was going to say about factual matrix. I do need to deal with one point, because I haven't dealt with the implied terms yet. And I wanted to deal with them after factual matrix, just because my learned friend says that factual matrix make a difference. The court observed that there are two implied terms, and it's just worth looking again to see what they are. Now, paragraph 26, I think, or 27, is this? 27, page 167, subparagraph 5 and subparagraph 6. So the first implied term, at subparagraph 5, there is an implied term of the touch agreement to the same effect. In other words, an implied term to the effect that the success fee is payable not just on sale of Project Craigmarsh, but howsoever the settlement is implemented. The first and obvious problem with this is that it is inconsistent with the express term. And it's Hornbook law that you cannot have an implied term which is inconsistent with an express term. So that if the court concludes that I am right and that the learned judge was right about the express term, meaning in paragraph 6, that a success fee is only payable on a sale, you cannot have an implied term which is inconsistent with that. And that is an end of that. My learned friend doesn't with any enthusiasm push the idea that the contract can't work without this, and that must be right, as the learned judge found. He places the weight of his case on the it's obvious. But in my respectful submission, why is it obvious? The learned judge in our respectful submission was completely correct in what he said at paragraphs 83 and 88. It's not obvious at all that if you're agreeing to pay a success fee for a sale, you're also going to agree to pay a success fee even if there isn't a sale. The learned judge in our respectful submission was also correct at paragraph 83 to say that the mechanism identified in paragraph 6, the 2% of the value, does make sense when you have a sale. Does it make sense in relation to anything else that might be done? Anything done in terms of the structuring of the trusts? In my respectful submission, it's not obvious that it's the same. One can quite see that if Mark was going to get readies to the value of 2% of 3 billion, he might be perfectly happy to give someone 30 million. Completely different if he's not getting that money. If in fact there's just a restructuring, which means some parties move to one trust and others move to another trust. Why is it obvious that he'd still be happy to agree to pay 30 million? So in our respectful submission, the learned judge was completely correct to say, for the reasons he did, that that first implied term can't work. I should just come now to the second implied term, which is the one at paragraph 6, the make whole point. Now, just to be clear, what is being said here is that if there's no success, because there is no sale, Richard should still get paid, should be made whole. So it's not really a quantum merit or a reasonable remuneration. We all know cases which involve those sorts of things. This is a very different case. He's saying be made whole. And I think a point that my learned friend didn't emphasize, but which is the case, is that this is not only looking backwards. He wants the additional 1.9 million for past work. He also wants future work. And I say that because that's clear from subparagraph 6A is the looking back. He wants his 1.9 million back. And if you go over the page to see...
So, sorry, where are we?
We're in the pleadings, I'm so sorry. Page 168, tab 10. So, implied term that if whatever happened didn't happen, he would in any event be made whole. And then you can gather from subparagraph A that it's looking backwards. He wants an extra 1.9 million above the 2.7 million, 2.6 million. And then if you go to C over the page, he also wants something going forward, which would be a traditional quantum merit. Now again, two main points to be made here. This is now completely inconsistent with Barton in the Supreme Court. And it is inconsistent with Barton for the very reason that, as the learned judge found, it cannot work here. It is inconsistent with an express term of a contract. In fact, it is inconsistent, I'm dropping my voice, it is inconsistent with two express terms of the contract. Now bear in mind that it is going backwards and forwards. If you go back to the touch agreement, tab 11, paragraph 1 says, for the work which was done in the past, I'm paraphrasing obviously, you get 2.6 million. This implied term says, actually, not 2.6 million, but more than that, if something else doesn't happen. That is inconsistent with what is said in paragraph 6. It is also inconsistent with paragraph 6 because paragraph 6, the reasons explained in Barton, is a provision which says you get paid if there is success, that is to be if there is a sale, but you don't get paid if there is no sale. And the effect of the term which is sought to apply is to ensure or seek to ensure that Richard will get paid in any event. It's what I think Lady Rose in the Supreme Court called a one-way bet. It's
Heads you win, tail you lose. Yeah.
What we call a cake and eat it. Have your cake and eat it sort of profession.
But your crake.
Crake and eat it. Can I just say something about Barton, just because it's newly come down and may be of interest? And you may have read it, you may not. But effectively what happened in Barton, the court will know the facts. There was a contract whereby someone who tried to buy Nash House and spent 1.2 million doing it, enters into an oral contract with the seller to say, if I find you a buyer for 6.5 million, will you give me 1.2? Because that's the amount that he spent, and he'd like to recoup what he spent. And the seller says, fine. He finds a buyer for 6 million. In other words, there's success, but not complete success. And the Nash House he sold for 6 million rather than 6.5 million. And the issue that arose, needless to say, the seller refuses to pay and says, well, I agree to pay you if you've got 6.5 million, but you get nothing even if you've got 6.44, 6.99, 499 million, you get nothing. Now this struck the Court of Appeal as very odd, and you had a unanimous decision by Lady Justice Asplin, Lord Justice Bales and Lord Justice Davis saying that there was an implied term or there was an unjust enrichment claim for the reasonable work done, a reasonable amount. Goes to the Supreme Court, and the Supreme Court overrules that. And it's a majority judgment. Malone kept saying you've got the same amount of lords on both sides, and numerically that's right, but it's a 3-2 judgment overruling the Court of Appeal and saying where you have a term, it really goes on the matter of interpretation. Where you have a contract and there is a term whereby you get paid if you do something, as a matter of interpretation, the meaning of that is you get paid nothing if you don't do that. And so Lady Rose, Lord Briggs and Lord Stevens interpret the contract to mean where you've got a contract which says you will get paid if you achieve this. As a matter of interpretation, it means that where you don't achieve that, you get nothing. There are very readable, if I can put it that way, and interesting dissents from Lord Leggett and Lord Burroughs, saying as a matter of interpretation they don't agree. And then there's a very interesting discussion about default implied terms and where there's work done. Very interesting. Again, the only thing I can say about it is its authority in my favour, that where you have a provision, I mean, I could say a lot about it, but I said I'd finish in an hour. Where you have a contract which has a provision which says you get paid if something happens and it doesn't happen, it's always a matter of interpretation. But Barton is a very strong indication that you get nothing. Can I just show you perhaps one paragraph in Barton, just because that is interesting? Maybe I'll show you.
We have 22 authorities, all of which I understand counsel swore and a stack of Bibles were needed to be referred to in order to decide this case. But
I refer to about 5.
at
I haven't taken
20
you
to
to
3, we're looking at one of them. Marvellous.
I could have taken you to more, my lord. I refer to our skeleton. Can I just show you?
Pulling your leg, Mr. Ravenevent.
Can I just show your lordship a few paragraphs, perhaps? I said one, but if you first go in Lady Rose's judgment, paragraphs 24 to 26 on page 389. Paragraph 24 on page 389.
Thank you.
I'll just read this to the court. Lady Justice Asplin thought that a term could be implied that Mr. Barton would be paid a reasonable fee if Weston bought Nash House for less than 6.5 million. She said that such a term would not contradict the express terms of the agreement. It was capable of clear expression. It was so obvious that it went without saying and was necessary to give the agreement business efficacy because the agreement lacked commercial coherence without it. As to the first point, I respectfully disagree. To hold that Foxbase are contractually bound to pay Mr. Barton an unspecified sum if Weston buy Nash House for less than 6.5 million does contradict the express terms of the contract under which Foxbase is obliged to pay him 1.2 million if Nash House sells for at least 6.5 million. Court of Appeal placed, I'm not going to read the, perhaps I will. The Court of Appeal placed great emphasis on the findings of the judge as regards to the discussion between Mr. Morris and Mr. Rook, described in paragraph 116 of Judge Pearce's judgment, where the judge rejected Mr. Morris's evidence that Mr. Rook had told him, Mr. Morris, that Mr. Barton had agreed that he would be paid the fee if and only if the property sold for 6.5 million. They regarded the rejection of that evidence, taken together with the judge's conclusion that the parties had not discussed the possibility of the sale being for a lower sum, as meaning that it would not contradict the express terms of the contract to imply an obligation to pay something in other circumstances. As Lord Justice Davis put it, the contract was not you will only get remuneration if you introduce a purchaser at a price of 6.5 million. Rather, it was you will be entitled to 1.2 million if you introduce a purchaser at 6.5 million. In my judgment, however, there is no material difference between those two descriptions of the contract. Whether or not the words if and only if were used by the parties in their negotiations, the effect of the contract as found by the judge was indeed that Mr. Barton was only entitled to be paid if the event that they agreed would be the trigger for that payment occurred. To imply a term that Foxbase is liable to pay a commission in any other circumstance goes directly against what the judge found the parties had agreed. And in my respectful submission, that is relevant. I can't say it's decisive because we have a different contract. But it's a helpful indication of how the Supreme Court looks at it. So too, if you go over the page 391, an agreement, just picking it up, an agreement whereby someone contracts for a higher than normal payment on the fulfillment of a condition and is prepared to take the commensurate risk of getting nothing if the condition is not fulfilled is not a bizarre or uncommercial contract. The well-known case of Cutter, I don't know if friend mentioned that, I don't think I need to take you through that. Just paragraph 37, I'm not going to show you that actually, it's just not worth it. Can I show you paragraph 96, which I think is worth it? You'll find that at page 409. Ready for this passage. I disagree with the analysis for reasons which mirror the reasons for rejecting the implication of a contractual term than this.
Right, so this is in the context of the unjust enrichment claim?
Yes, it is, yeah. And there's a lot of reference to the ladyship's decision in the Avonwick case. Where parties stipulate in their contract the circumstances that must occur in order to impose a legal obligation on one party to pay, they necessarily exclude any obligation to pay in the absence of those circumstances. Both any obligation to pay under the contract and any obligation to avoid an enrichment they have received from the counterparty from being unjust. The silence of the contract as to what obligations arise on the happening of the particular event means that no obligations arise, as Lord Hoffman made clear in Belize, cited earlier. This excludes not only an implied contractual term but a claim in unjust enrichment. Now, although that is stated as if it's almost a rule of law, it obviously depends on the interpretation of the particular provision, and we accept that. You could have a provision, you might have a provision where the parties do stipulate circumstances that must occur to impose a legal condition, a legal obligation, but there may be other provisions in the contract which means that what follows doesn't necessarily follow. But it would have to be a strong case on the basis of this. As I say, Lord Leggett and Lord Burroughs had a different interpretation of the contract, which was more in line with the Court of Appeal, and that enabled them to come to a solution as they sought in either implied term or unjust enrichment. So we say on this implied term, not only is it inconsistent with the express language for reasons identified in Barton, but this really is a case like the Barton paragraph 96 case as well. And subject to the court, I'm not sure I need to say any more about implied terms of Barton. I'm not just trying to finish before the hour, but that's all I think I can usefully say about it. I need then, I think, to move to ground one of Miller and Friends' bill. I know I've gone backwards. Ground one, as I identified at the outset, involved 2 points. The first was relating to the fairly obvious point that where, in terms of the weighting that you give to the language versus factual matrix, where you have a contract which is produced by city solicitors, you're more likely to give more weight to the language than you would in a more informal contract. And the second point, if I can identify both points, is the Plusnik point, the unforeseen circumstances. Now, so far as concerns, which I think I've dealt with, so far as concerns the informal contract point, think the first thing to say about this is that the learned judge was absolutely alive to this point. And indeed, he not only cited the relevant passage from Wood, where this is set out, that's the Wood and Capita case. If I can invite you to go to paragraph 50 of the learned judge's judgments, that's tab 7, beginning at page 95. Refers to Wood and Capita, and then if you can go over to page 97, we're still in the Wood and Capita quote, in line with what would be B if there were side markings. You see that Lord Hodge refers there to the correct interpretation of other contracts may be achieved by greater emphasis on the factual matrix, for example, because of the informality, brevity, or absence of skilled professional assistance. So the learned judge cites authority which makes that point. Not only that, but if you go to paragraph 56 of the judgment on page 100, he expressly says that he bears in mind that he's dealing with a homemade contract and that the factual matrix may be more relevant in this case than in other cases. So he has this point. It's not like as if he overlooked the point. But my lords, my lady, it's an obvious point again. Sorry to keep making points that I say are obvious, but the spectrum between well-drafted city solicitor type contracts and homemade contracts, well, it is a spectrum. It's scalable. And in terms of where we are on the spectrum or the scale, we're not in the city solicitor. This couldn't have been more than a 5-page document, one imagines. We're not in that world, but nor are we in the Barton world of an oral contract made over a telephone. We're in a world somewhere between the two, where a professional person who considers his services very valuable, he was charging out at more than £900 an hour, far greater charge than most of us, and certainly more than city solicitors at the time, perfectly capable of handling very complicated matters, because that's what he thought he was being entitled to 4.6 million. Took time and trouble to draft a contract in which he defined a term. Why do I say that? I say that because I don't dispute that this is a more informal contract. But the doctrine that you can have regard or more regard to factual matrix doesn't ever mean that you can disregard, except where there's a mistake, the language that parties have chosen to use in the contract. And that is especially so where you're dealing with someone like Richard, who's plainly not unintelligent, who is a professional person. He is an accountant. I don't say that means he's a master drafter, but he's done a perfectly decent job. Reference to this doctrine of informal contracts doesn't mean you can ignore the language which is actually used. I should also say that in addition to Wood and Capita, my learned friends also refer to a judgment by Lord Justice Leggett in the Court of Appeal, in a case called Maneras against Glen, paragraph 31, where effectively the same thing is said. So it's not new law, it's well established, and it's in a sense an obvious point. But again, in our respectful submission, it really doesn't get my learned friends anywhere. In particular where, as we see from paragraph 28 of their pleadings, they expressly assert that the terms of the contract were set out in writing. Ladies and lords, that was, I think, all I was going to say about grounds 1 to 3. There is also obviously a ground 4. My learned friend didn't say anything, and in my respectful submission, he was right to say nothing about ground 4. Ground 4 is the point which says that even if the court is with us, that this case is hopeless as a matter of law, it should be allowed to go to trial anyway. And in my respectful submission, there is nothing to be said in favour of that. And that's presumably why my learned friend said nothing. And I'm not going to take up time responding to something he didn't say. if any of that makes sense. Subject to the court, that is all I was proposing to say.
Thank you, Mr. Rabinovitz. Mr. McGrath.
My Lord, can I ask the court to take up bundle supplementary bundle, tab 8, page 63? Just to make one very short point, you've heard the figure of 30 million and 27 odd being bandied around. My Lord, on the in that bundle you will see there, appreciate it's a letter written in 2007.
Sorry, S64.
63.
Yeah.
Tab 8, page 63 of this bundle. The supplementary bundle. And one can see there a letter dated the 15th of May 2007. And I don't want to labour this point, I just want to make the point by reference to this. You can see there that there's, in the second paragraph, I'll ask my trustee, this comes from Anthony, to acquire from NB1 and NB2 trusts their interest in the JCB group for 650 million. I and the other beneficiaries will consent, if you so wish, to 50% of the price, 325 million, being distributed to you or transferred to another trust where you're the sole beneficiary, etc. The point is that it would be wrong to take a valuation of JCB as a whole and then say you worked at 2% simply from that without recognising and understanding what price Mark Bamford would have to pay for the disentanglement of his interests. One can see there that he wasn't getting the full price of 650 million coming from the two trusts that are in his name, which represent 50% of the interest. So it's simply to say that one can't safely bandy around such large figures as was the case in my friend's submissions. Secondly, we say that we're not asking the court, we've made this point before, so I'll say very briefly, we're not asking the court to completely disregard the language used in the contract, as opposed to understand it against the background of that actual matrix. And that understanding informs the reader, the objective reader, that what is said in paragraph 6 by way of sale is not the only trigger for the payment of the 2%. And we're using the factual matrix there to interpret the language, not to disregard it or completely disregard it, as I think my friend says. The point that the judge raised against my client's court below, that there were more than one options, etc. So they've made a choice. And we say, but the question is whether that choice is a choice that implies that the others have been excluded, or is simply an identification of which is the forerunner of several that could be included. And so we take to the view that, and this is really a general point made against the interpretation of paragraph 6, that it does not involve the inclusion of the terms there, do not involve an understanding of these parties that meant one excluded other means to achieve the separation of interests. We do stress the attendance note that deals with the 2.6 million and its characterisation, and to deal with the point, we're not relying on it for the cut and thrust of how the sausage was made, but simply that it was understood a sausage was made. That's the distinction, and we say that that's entirely admissible for the court to say that it is a down payment. It is not the entire payment, which then, when one understands that, I've addressed you on the connection between paragraph 1 and 6, and I won't do that again, but it was said against me that one of the reasons why one couldn't imply a term of the second implied term basis was because you'd already been paid 2.6 under paragraph 1, therefore it would be inconsistent with paragraph 1. Well, we say that's not right when one understands, as I've made clear, paragraph 1 is characterised as an advance payment, not entire payment for what one is due. And as regards Barton and Morris, you have my main submissions on that, which is that when one properly understands the success fee, Mr. Richard Bamford plainly does not stand in the same shoes as Mr. Barton, nor does it form part of our case that we're asking for any lesser success to give rise to any payment. The success, remember the hotel, the success is the same however one gets there, and that's what we say. But just going to the decision itself, and just one paragraph I wanted to refer your lordship and ladyship to. It's in the authorities bundle, tab 18, and it's page 412, and it's the concluding the section of Lady Rose's judgment, and she says at paragraph 107, page 412, I do not consider that there is to be found in this court's judgments on this appeal any fundamental disagreement about the underlying legal principles, although they may be given different levels of emphasis. The real difference between us concerns whether the express term that Mr. Barton was to receive 1.2 million if the property was sold for 6.5 million to a purchaser introduced by him was a complete statement of the circumstances in which he was promised some reward under the agreement, or only a partial statement, leaving it to be implied that he would also receive some unspecified reward if the property was sold to such a purchaser, but for less than 6.5 million. If it was a complete statement, then a lesser reward for sale below could not be implied, because it would be inconsistent with the condition for the reward expressly agreed. And it's formed part of my submissions to the court today to say that the, as understood by informed bystanders and read by informed bystanders, the arrangement reached as set out in the trust agreement would not exclude payment of the 2% in circumstances where the separation of the trust has taken place other than via the one identified method of the sale of JCB. And it's interesting to know Lady Rose's statement there, and of course the bits that my friend read out, in which it was emphasised that it was the findings of the contract as made by the judge in the court of first instance court, that it would be inconsistent with those findings to say it wasn't a complete statement. And we say here that it is not a complete statement of the position for the reasons that I've addressed you principally this morning, and therefore we are out with Barton. But we're out with Barton in any event because we're not asking for payment on a lesser occurrence, and we're not asking to treat Mr. Richard Bamford in the same way as Mr. Barton was. He simply wasn't at the coalface for the sale, and therefore success doesn't make sense. And I just emphasise that point, if I may. The judge was keen to stress the commercial sense of his understanding of the arrangement, and yet we say it makes no commercial sense at all to describe paying 2% for the sale of JCB as being a success fee, as understood, on the part of Richard Bamford. But it does make sense to describe the success fee as being as a reward for the separation of interests under the trusts which he had secured. And so we pray and aid that. And I think, my Lord, as regards ground 4, my friend's right, I didn't spend much time on it, but I made the point at the very beginning, although I believe I was somewhat shot down by the Master of the Rolls. I tried to duck and dive, but I think some bullets might have hit. When I mentioned the oddity of the situation that we've now found ourselves in, that the judge's conclusion is one that neither of the protagonists that were at the party would have agreed with or would agree with if this matter were to proceed to trial. Well, can I just check? Well, they were the submissions I wanted to make in reply.
Well, thank you very much. Thank you very much, both of you, and your juniors and solicitors. An interesting argument, and we'll take time to consider our judgments. When you get the judgments, will you please agree in order and send us any typographical but not other corrections, and bear in mind the terms of the embargo, that you're not to use that judgment for any purpose whatever except agreeing the terms of the order and sending corrections. And I think that's all I need to say. So thank you for your expedition and economy in both cases.